Welcome to this web broadcast. We're going to give you the updates on the proceedings in Julian Assange's hearing that was basically postponed this morning when it was found out that one of the lawyers of the prosecution or the partner of the lawyer was diagnosed with symptoms, possibly COVID. So the proceedings were delayed or postponed until Monday, and we'll know before Monday whether there will be further delays or further tests needed. This is the influence of COVID on the proceedings here. We're going to discuss a little bit about what has been going on the last 3 days. With me are Jennifer Robinson and Joseph Farrell, and we've been in the courtroom and observing the what has been going on since Monday morning, since the incredible start on Monday morning when there was an attempt to actually have the new superseding indictment, or the elements that were put in there only a few weeks ago, dismissed by the court. That request was denied. Then there was a request by Julian's lawyer of German for a few months, and so he could, the lawyers, prepare properly for the new indictment that was put into the court only a few weeks ago. That request was denied as well. But we have since then heard very important witnesses testifying in court. We have heard from Trevor Tin, who is the director of the Freedom of the Press Foundation, from Paul Rogers, a political scientist and a distinguished author of, I think, 9 books on the war on terror. So he's an expert on Iraq and Afghanistan, those wars. And we've heard as well from Clive Stafford Smith, the director of Reprieve and founder of the organization, a human rights organization that has now for 20 years worked on the behalf of Guantanamo Bay prisoners, those who have been subjected to torture by the CIA, and on behalf of victims who have been basically assassinated in the assassination programs of the U.S. administration, the CIA and the courts. And we have heard from Mark Feldstein as well, a distinguished professor in the field of journalism and media. So maybe let's just discuss these testimonies. I mean, what is the highlight, Jennifer, in your opinion, of these 4?
Well, I think there's been so many highlights, really, and what I think has been important is each of these witnesses have spoken in different ways about the importance of WikiLeaks revelations and the Manning disclosures. So for me, as a human rights lawyer, Clive Stafford Smith, the founder of Reprieve, was really important because of what he talked about, both in terms of the importance of WikiLeaks disclosures about the US extraordinary rendition program, US use of torture, and of course drone strikes and extrajudicial killings in Pakistan. And of course the Guantanamo detainee reports. He discussed each of those publications which traverse the Guantanamo publications, the State Department cables, Iraq and Afghanistan war logs, and within that material he talked about how important the WikiLeaks disclosures were, in particular in creating a sea change, what he described as, quote, a sea change in public opinion about drone strikes in Pakistan, how important all of this documentation was in his own efforts to litigate against these issues, so holding the government accountable in respect of Guantanamo Bay in litigation in the United States, using WikiLeaks material in the context of their various litigation proceedings brought in Pakistan to hold the prosecutors accountable for not taking action against the CIA for these unlawful killings in Pakistan. So for me it was really important as a lawyer that Clive was able to communicate to the court and to the public how important WikiLeaks disclosures are for human rights accountability. I think for me also the other highlight was the evidence that we heard from both from Trevor Tim yesterday and from Mark Feldstein about the First Amendment and free speech implications, what this case means for the First Amendment in the United States, and also what it means for journalists everywhere. I think it was really interesting hearing the way that Professor Feldstein located this case in the history of the way in which the Espionage Act has been used against publishers. Of course, this is the first time it's ever been used against a journalist and a publisher. It's the first indictment in the history of the Espionage Act. Though we heard in evidence about the history of how President Roosevelt and President Nixon both used this act to threaten publishers for political reasons. And that is such a key part of our case, that the Trump administration is using this indictment as a political tool in its war on journalism and on the press, and how this case will be used as a Trojan horse and as a method to start criminalising the actions of journalists in the United States and elsewhere.
You, Joseph, what was the highlights in your opinion?
I thought when Clive Stafford Smith was talking about the actual indictment, he brought up the fact that part of it deals with conspiracy, and that if Julian were to be taken to the US, it becomes a Pandora's box as to what can be used against him, that they could bring in an expert witness that would give an entire history of terrorism or of espionage or of conspiracy, and it doesn't matter what's in the indictment now, that could be completely redefined. That was with Clive Stafford Smith. And with Trevor Tim, I thought what was very interesting was the way he said that nothing, and this goes to how misleading the indictment is, nothing that has been done has been illegal. Nothing that WikiLeaks is alleged to have done was illegal. And in fact, there was a time in 2013, I believe, where the Congress was asked to bring in a law, a shield law, that would have made it illegal, but they rejected it. He pointed out also that the indictment really there is only space for one to survive.
Yeah, it is extraordinary. There was very strong testimony there to these two elements that you pointed out, Jen. On the one hand, the tremendous importance of these leaks, these publications, in exposing basically the truth about the Iraq War, the Afghan War, which at the time, it's forgotten now, that at the time we were led to believe that the Afghan War was basically over, that it's just a few pockets of resistance and it would be over. And it had been a successful operation until then. Of course, the Afghan war logs dismissed that theory. It was far from over. It had been going from bad to worse until 2010. And in fact, we're still there. It's the longest war in the history of the United States. It's still ongoing. And the same applies to the Iraq War. And that is it was so clear in the testimony the importance of the leaks for the public interest. And then on the other side, of course, so firmly establishing this is a journalistic practice. There is nothing that WikiLeaks and Julian Assange did that were not firmly protected in the First Amendment. Nothing at all. And the issue of whether Julian is a journalist or not just doesn't matter. It's completely irrelevant in the context of the U.S. understanding of the First Amendment. It's the journalistic practice that is protected. So this endless debate of whether he's a journalist or not is just irrelevant. So it was very compelling to hear that.
And also to hear the other thing Trevor went into was the fact that there are 80 mainstream media organizations in the US that employ the same tactics as WikiLeaks has and does, and some of them have gone even further insofar as taking adverts out in the press to encourage people to come forward with information.
Exactly, and I think one of the things, this idea of solicitation, so at what point does a journalist's communications with a source or a potential source become, as the US government would say, unlawful solicitation? And what we heard from Trevor was the existence of how many media organisations now have secure drop boxes, which is exactly what WikiLeaks does. How many media organisations put out specific adverts about people giving them information. Yeah. How many journalists ask for specific documents from their sources, and how regular a practice this is in terms of journalistic activities. And so I think after the last few days of testimony, certainly those who aren't already familiar enough with the case are now starting to understand what the implications of this would be. I think what was also important was Trevor Tim's testimony pointing out how misleading the prosecutor's description of the indictment was, pointing out that the case does in fact involve passive receipt of information. So simply, if you receive the information and possess the information, that is a criminal act. For national security journalists, and as Trevor Tim pointed out, and as Mac, we heard about the evidence many years ago in the Pentagon Papers case in the early 70s, if it is a crime for journalists to receive and possess, before we even talk about communicating to the public and publication, that will put an end to all national security journalism.
And he went even further to point out just how overreaching this indictment is, because it also goes so far as to mean that anybody who reads information in a newspaper that was classified is equally liable.
It was so illustrated that they were going back to the Nixon era and the Pentagon Papers and Watergate scandal, and that was actually, at that time, Nixon wanted to get the journalists. They wanted to get them on the Espionage Act, but in the end they didn't, because the First Amendment implications. So even Nixon didn't dare to go where Trump is now going. And the fact that they were pointing out that if these measures, if this current understanding of the limitation of journalists would be applied to Woodward and Bernstein, they would have been prosecuted under the Espionage Act for having interaction with their source, Deep Throat, for going back, asking for more interaction with them. And in terms of the Pentagon Papers, the New York Times journalists had access to the room where the papers were kept. They were actively taking part in copying the papers. So they would all have been guilty. So that's where we would be at. So it's very illustrated to go to these examples, because they're well known. They are hailed today as ground journalistic practices of the past era that we want to copy and emulate today. So that would have been a crime today, if today's sort of understanding what is underlying in the whole thing. What I've failed to understand from a legal standpoint is that the prosecution is constantly trying to mislead the witnesses here. We can talk about the harassment that we are witnessing by pointing to one statement, basically, or affidavit by Kronberg, the Assistant Attorney General, pointing out that this is just about this limited issue. This is just about revealing names in cables. It's not about the whole thing. Whereas actually the indictment clearly states it's about receiving and possessing the information. How can you attempt? What are you going to read into this? Are they trying to? Are we going to get a new indictment soon? What does this imply? This sort of game.
It does feel like it's a game of obfuscation as to what's really going on.
Well, I think the U.S. prosecutors are trying to present this as a case they're desperately trying to distinguish between what Julian, as editor and publisher of WikiLeaks, does and what the rest of the media does, and unsuccessfully so far. Because as we've heard from Trevor Timm yesterday in his testimony, you can talk about, they keep talking about responsible journalism. And as he said quite forcefully and I think effectively yesterday was, well, we can talk about editorial responsibility and everyone takes a view on editorial responsibility. He said he might not have agreed with every publishing decision made by the New York Times or by WikiLeaks in this instance. But it's not for the US government to make editorial decisions like that, or to step in to criminalise those editorial decisions. And he made very clear that the publication of names of informants, even if it were to put people at risk, while that is undesirable and to be avoided, it isn't a crime. And I thought,
and also to be noted is that to date they haven't found any case of harm having been caused by any actions that were taken.
Well, it's both about the evidence in this case, and of course there is no evidence that anyone was harmed, but even if you look at the principle, even if the allegation is that there were people harmed, that it doesn't make it a crime. So I think that was really important in terms of what came out yesterday. But you mentioned sort of the historical examples of those involved in Watergate and the Pentagon Papers would be prosecuted today and convicted under the prosecution theory that the Trump administration is running. But it goes further than that, because what the prosecution theory is in this case is that by having those communications with the source, journalists are complicit in the underlying unlawful act of the source. And so to explain that in this context, Chelsea Manning made unauthorised disclosures in breach of her obligations under US law as a military officer. Now, we can all debate about the policy issues about whether there ought to be public interest offences for those who engage in principled whistleblowing on war crimes and human rights abuse. Leaving that aside, we have always noticed, and Professor Mark Feldstein talked about this, the source-journalist dichotomy, which is, it may be that your source engages in unlawful activity or breaks the law or their own obligations in making an unauthorised disclosure about wrongdoing. But it is accepted under the First Amendment that journalists are able to receive that information and publish it, protected by the First Amendment. What this case is doing is breaking down that distinction so that journalists who are communicating with sources are being found to have conspired in the underlying unlawful act. And that is dangerous. And we know how dangerous that is because it is the precedent being pursued in this case. It will effectively mean that, again, national security journalism is dead. But we're seeing it rolled out in other places, like with President Bolsonaro in Brazil, the case theory was used to pursue Glenn Greenwald, that he is, having received information, he is somehow complicit in the underlying act of hacking that's been alleged against the source. So I think it's a very dangerous precedent that goes above and beyond what has historically been considered legitimate news-gathering activities.
People don't have access to the courtroom, only a handful of people are allowed in there in the public gallery. So let's give them a little bit of insight of what's going on there. It struck me, and unfortunately I've been in a lot of hearings in this country, but it was the way the prosecution, Mr. Lewis on behalf of the U.S. government, was attacking. What I felt was attacking the witnesses, the expert witnesses, and basically accusing them of bias, trying to undermine them in a very, very. Have you seen this happening before in this sort of in this fashion that was played out in court?
Look, we have an adversarial system in this country, and it is his duty as the prosecutor to cross-examine and cross-examine hard. And it is a typical strategy, particularly when cross-examining expert witnesses, to attack them on the validity of their expertise and their objectivity. So these are cross-examination tactics which are to be expected in the context of expert evidence.
Well, it went a little bit further than that. I mean, it was like an accusation of tone, and he started asking witnesses about a lot of issues that were outside their field of expertise. And they were constantly saying, this is not my expertise. I'm a witness on this, on journalism or political science. And
well, he would frame it with a question, are you a lawyer? No, I'm not. And then he would lay into a whole lot of hypothetical questions and legal questions.
I think all of the witnesses performed incredibly well, and I think their testimony stands for itself.
There were not a lot of counter arguments that you could read into the cross-examination. It didn't seem that the prosecution did have any ammunition of substance in a way. What's your thought on that?
Well, I thought what was interesting in relation, just following up from what you said about how the prosecution is trying to separate Julian from the rest of the journalistic community, that was dealt with tangentially with Professor Rogers when he was pointing out to the prosecution that the Obama administration had brought a case but not pursued it because they found that they couldn't differentiate Julian and WikiLeaks enough. The prosecution lawyer really did his utmost to try and break that down, saying, but do you admit that an investigation was ongoing? He said, well, I don't know if the investigation was ongoing or not, but it's irrelevant. The point is, and the fact is, that the Obama administration didn't bring a case. How do you know that? Because it didn't happen, was the answer.
We know the date of the indictment. It was the Trump administration.
And also he brought in, since his field of expertise is politics, he had actually brought in to the discussion the levels at which decisions are taken, how high up, whether it's at a Department of Justice level or if it's something far more politically motivated from higher levels, which was enlightening.
Well, it shouldn't come as a surprise to anybody that especially under Trump, the Department of Justice has been very politicized. I mean, that's what you're reading in the press every day, and there's a very harsh criticism on that. But that's a fact that everybody notices in that country.
Yeah, backed up by the fact that he's tweeted 2,200 times against the press specifically, and admittedly only to cause them trouble in some cases.
And the fact of the matter is that you cannot point to anything new. Everything that is basically, even though we of course don't have all the evidence, we don't, because that's on the seal in Virginia, but what comes out in the documents that have been presented is that nothing new has been added to what was scrutinized under Obama and the decision made there not to go ahead with the prosecution. That in itself speaks a volume of how political the decision is to go ahead now.
I thought that was made out quite clearly by Professor Rogers in his testimony, setting out what I thought was a very interesting history of WikiLeaks and Julian's approach to WikiLeaks and in the context of reporting on war, and talking about how WikiLeaks was set up in the context of the Bush era. Some of the major publications by WikiLeaks, we saw Collateral Murder, Afghan and Iraq War Logs, directed at the war, Julian's own speech at the United Nations talking about accountability for US war crimes, the fact that it's not a war against the United States, that he spoke clearly in that speech about how there are good and right-thinking people in the United States who want to take action about this, and this is specific wrongdoing and human rights abuse by people in government and in power who need to be held accountable, and his political opinions around that, in terms of
Julian's political
opinions around the importance of human rights, transparency and accountability, have put him in direct conflict with the Trump administration, which is at odds with the media and at odds with organisations like WikiLeaks, who are now considered a threat against national security for revealing government wrongdoing. And his conclusion when asked on cross-examination was that this case is a political case, and one that he believes is politically motivated because of that conflict.
And because of Julian's defined political beliefs.
It was the attempt was made to highlight the fact that the evidence had been scrutinized by a grand jury in the United States, so therefore there was legitimacy there without outside the political scope of looking into the evidence and bringing forth this indictment. But of course, on the other hand, it was pointed out that, as the saying goes, you can basically get a grand jury to indict a ham sandwich, and in 99.9% of cases, a grand jury will come up with an indictment. I think the numbers were only
134,000. In 134,000 cases, only 11 came back without indicting, and that's something that surely needs to be addressed from a legal point of view. The fact that somebody can be facing and be sent to another country for 175 years and no evidence needs to be provided at this stage, that all they need to show is a belief that, maybe you can put it more eloquently, Jen, the belief that there is a possibility to indict, not actually have to show the evidence. And as the prosecution said to one witness, well, you can't have seen the evidence because it's secret.
Yes, an excellent point to put out. Look, I think there's a real question about the process and what people like Julian go through in these kinds of extradition requests, where we don't actually get access to the full evidence file. Extradition cases don't involve a criminal trial, a full criminal trial on the underlying allegations. It's a very technical challenge where we have to raise statutory bars to the extradition itself, which doesn't necessarily involve, except in this case, looking at the underlying facts. Except here, where the facts come in is our abuse arguments around the way that the United States has misled the court and the British government in terms of misleading in the description of facts in the indictment to justify his extradition. And there were numerous examples which have already been referenced in open court and in the arguments in February and now around the way it's suggested that Julian somehow solicited the material from Chelsea Manning with the most wanted leaks list, but of course we have evidence from Chelsea Manning's own criminal trial where she says that she chose to provide that information of her own accord and based on her own conscience. So, and takes full responsibility for her decision to do so, wasn't motivated by, influenced by anything that WikiLeaks had said or published.
And also on top of that, of course, the most wanted list is not an editorial list by WikiLeaks.
Precisely.
It's it was a wiki. So I mean, the people out there actually were editing this list of their preferences, what they wanted to see leaked. I mean, it's like a newspaper. Please send us suggestions. What do you want us to cover? So this didn't come from WikiLeaks.
That's
this
right.
So-called most wanted list.
What's also offensive about that narrative of it is that they're suggesting that Chelsea Manning had no agency of her own. She didn't. She was merely a pawn in Julian's scheme. It's an offensive route to take when she's already expressed that she did it out of her own good conscience and without influence.
Precisely.
What about access to these proceedings? Of course, we had this spectacular issue on Monday where 40 observers, we call them, from organizations like Amnesty, from Reporters Without Borders, PEN International, they had been given video access to the courtroom, but then suddenly on Monday morning the barrister, Judge Baritzer, said this had all been a mistake and they were all cut off, which is without any explanation of why that happened. We just explained as she had made a mistake in allowing that to happen. It must be concerning that all these interested parties are kept out of being able to observe these proceedings.
And that is what Amnesty International does. It's their bread and butter. They are court observers. I heard Reporters Without Borders had the same thing happen to them, and they said, well, actually it's quite interesting because it's what we've come to expect with this hearing. It happened to them when the hearing in February, it's happened to them now. Them getting access to observe, it's become impossible for so many people. And these organizations are throughout the world.
I think there's been real issues with access to these proceedings and open justice. Open justice is one of the most fundamental pillars of our judicial system in this country, in terms of both Julian's right to have a fair trial and the right of the media and the public to observe and scrutinise these proceedings.
Proceedings which will affect the media themselves.
Well, precisely, but it's true of any case like this, and it's considered part of the right to a fair trial and also protected by Article 10, freedom of expression, and the importance of the media in terms of having access to these proceedings to be able to report it to the public is seen essential in holding our courts to account to ensure that procedures are being followed properly and made transparent. But in this country, of course, we're seeing a lot of teething difficulties around online access, because a lot of this, historically, you wouldn't have any online telephone or video access to proceedings like this, which of course has changed with the nature of the COVID pandemic. But it goes beyond that. So we do have journalists who have remote access, but it's a limited access, so not as many journalists who would like to have access. We've had NGOs who have not been able to get access, or at least were promised access and then had it removed on the day. And this was incredibly problematic because we had EU politicians, PEN Norway, groups who are based outside of the jurisdiction who chose not to travel, to come here and take the risk of travel during the pandemic on the basis that they would have access to the proceedings. And by virtue of this decision being made on the morning of the hearing, are now suddenly bumped out and can't observe. And so, I mean, I've heard from RSF, Rebecca Vincent has said that she travels the world attending trials like this that affect freedom of expression, and she has been saying that she has never had so much difficulty accessing a hearing as she has in the UK. And what does that say about our democracy? We've also seen that limited seats in the public gallery as a result of social distancing, but that certain seats are being allocated or kept for VIPs, none of whom have showed up or we know who they are, which means that Reporters Without Borders are sitting outside waiting to see whether these people, whoever they are, to show up, and missing half of the hearing. And then they're having to bargain their way into court each day. And this is really, I think, it is not in the interest of open justice, but it's also not in the interest of maintaining the credibility of showing the transparency and access to the courts in this country, which is, open justice is such a fundamental pillar of British justice, and it's a shame that there are so many problems in this case.
Let's wrap. Any final thoughts on the coming days and weeks?
Well,
if we're able to continue Monday, we don't know.
I just want to follow up on access. It remains the case that Julian still doesn't have immediate access to his lawyers, both in the court. You know, he's 5 or 4 rows away from his barrister. If he wants to interject, as anyone could normally, he has to stand up, he has to get the attention. It's a very bizarre situation. He can't confer privately or discreetly, and also his lawyers don't get to spend much time with him.
That's right. So on Monday morning when he arrived, we hadn't seen him for 6 months. I hadn't seen him in person since the hearing in February because of the restrictions on the prison with COVID. But more importantly, he hadn't seen trial counsel who were arguing the case. He hadn't even seen the written submissions because no one could go to visit him to take him in the papers, that we had to rely on the post to get it to him. And because the post is so slow, by the time the submissions were finalised, so Julian turned up on Monday, hadn't read the submissions, was served with a second superseding indictment, and the hearing had to be postponed to allow even just half an hour for his counsel to be able to discuss with him what that new indictment meant and what it was going to mean for the proceedings on Monday. So all in all, his access and his ability to communicate with his legal team, with all of us, is significantly
worrying.
Well, it's a real concern.
A real concern, yes. Well, thank you for this. We'll do this again, I hope, and thank you for watching. We'll be probably back here on Monday and continue observing what will